So, hello and welcome to this session of iMoot 15. We have Ralf Hilgenstock talking about legal aspects of e-learning in Germany. Ralf is the owner of the Moodle partner Liability. And thank you very much, Ralf, for your time today presenting. And I hope everybody enjoys the presentation.
Okay, thank you for this introduction. This is a very challenging presentation for me because I'm not a lawyer and I'm talking about legal aspects, one element. The main one here was when I prepared this session, I found that's not so easy to transfer the German legal terminology into the English so that someone coming from another country will understand it. And I found that a lot of terms that are used in German, if I'm directly translating them, they will have another meaning in another country. And this is a point where we have to be a little bit careful during this presentation. The second challenging point is that my girlfriend will sit here nearby, and she is a professional lawyer, and she is specialized in data protection acts, in copyright issues, and at the end she will tell me, "Oh, Ralf, this other point that you have done quite well, but the other one that were not exactly correct." Will be an interesting discussion after this presentation if she gives me a feedback here. I have to make a preface for this presentation. It's based on German law because I'm not a professional lawyer. I haven't studied law here in Germany, but during my work with e-learning and in the training area, since more than 30 years and in e-learning since more than 10 years, very often we came to the aspect of the legal aspects if we discussed with our clients, and they asked what are relevant elements, and I researched a little bit about it over the years, discussed a lot with lawyers, followed the legal discussions there, and finally I said, okay, I want to summarize all this information, and what I'm telling you is the general overview, what I have found out over the years about these topics. And there's one point that I have to say in a moment, because there's a special act here in Germany. I can't, and it's not allowed for me to offer any legal consulting, because this can only do the professional lawyers that have studied this. And I have to make this preface so that it's clear for everyone who is talking with which background here in this presentation. If you want to leave now because you say, okay, there isn't a lawyer, I don't want to hear it, no problem, but I will try to do my very best. So what are the areas, what are the fields of legal aspects if we are working in the e-learning area? It's a very different one, but not all of them are relevant for everyone who is working with e-learning here in Germany. One element is contracting. How are the contracts done with the participants? In which way? This may be very relevant, even also relevant for the type of e-learning you are doing and the special contracts you are doing, because there's a special law act here. Data protection, I think this is a worldwide topic, an issue. How is data protection organized? What are the requirements for data protection? What can you do with the data? Workers' council rights, maybe very special German aspects in corporates. Workers' council have a very good position, and they have to be asked for several aspects. Copyright, or I have to be more correct, German Urheberrecht. Copyright is a direct translation, but copyright in US, in England, means quite something different than Urheberrecht in Germany. Then we have several acts about internet applications. We have to be careful. And one curious thing, if you are doing some types of e-learning, maybe that it is broadcast. And you have to register if you are broadcasting or you need an approval for what you are doing. But it's a very, very special, a little bit curious situation. And so I will put it at the end of this presentation. If you have any questions, I'm going to the points, take the chat, write your questions, write your ideas here. So let's start with the contracting areas, and there are two sources for this. One of them is the acts relating to online contracting, generally to online contracting, not specially for e-learning. This is a typical situation that there is no separate act handling and defining anything about e-learning here in Germany. But we have a lot of acts that are related to e-learning if we are working, and you have to be careful not to follow this acts in a transferred way. Second one, and this is an act that is not very well known here in Germany, is the Distance Learning Act, Fernunterrichtsgesetz, or Act for protecting consumers in distance learning in detail. And I will go through this two areas. First, about the online contracting. If someone sells anything on an internet platform, there's defined a lot of details about the sales process here. At first, I have to give very concrete and very detailed information about the payment fees. I have also to give information about the cancellation policies. And it's going so much in detail that this is defined by an act or an attachment to an act, how the button has to be named if someone finally closes a contract and buys the product. And if you are not handling it exact in this way, if you don't give the information, if you don't give any information about cancellation options for the participants, if you don't send them in a confirmation, it's possible that the participant said, okay, this is a contract that is not closed legally, and I can reject it every time. I can cancel it every time. So you have to be very careful if you are doing some online contracting and asking for a fee for this. Then the second one, it's related also to the contracting, is the Distance Learning Act. Distance Learning Act is very interesting. It's an act that is founded in the 70s of the last century. And the situation there was that there was a lot of service provider for distance learning, not related to e-learning. They prepared learning books, sent the learning books to the participants, asked for some assignments, they sent them back via mail, via snail mail to be correct, and then they gave them feedback, the sort of situation. And several of the service provider in distance learning here in the 70s announced that people can make a training program, a learning program very easily, have to buy a lot of money, but they didn't send appropriate materials to them. And so the government said, okay, we need an act to protect the consumers in this situation. And then they have defined what is distance learning. And they have also defined what are the options to cancel such a project, such a contract, and what is what is required that the contract is really guilty. At first they defined what is distance learning. They said a distance learning project or offer is something that has more or than 50% of the learning time in distance. Some of the providers said, okay, we have on-site trainings and combined with distance learning. And if there's more than 50% distance learning, then it is related under the Distance Learning Act. I mentioned that this act was founded in the 70s. And in the 70s, nobody thought and had an idea that e-learning will come. So they didn't write the act with elements of e-learning in the background. And today we have e-learning. And how does it work together, this old one? And 2 years ago, I asked the state agency that is in responsibility for this act a lot of questions, and one question was, how did you calculate the learning time, and what exactly is distance and what is exactly on-site learning time? And they gave me a very curious answer about it, and they said, okay, if people are sitting together in a room, this is on-site learning time. That's quite clear. If we have an online session like we have here in the moment, this is also on-site learning time. If we have a chat, it's also on-site learning time, because all of the participants have to be at the same time and join the session. So far, so clear. But they said also, if you are offering a recording of the session, it's possible for a participant to join it afterwards or to repeat it again, then the same time is calculated as distance learning time. I checked the act and said, where is this defined in the act? And as expected, nowhere in the act any information about this were written down. And so it's very unclear how it is calculated. The second criteria there that this distance learning act is relevant is that is normally a paid course. If participants normally don't pay for a course, then you don't have to cover this act. Then third criteria is the learning success is controlled individually. What does it mean, this controlled individually? And I asked them, what happens if I have a quiz in a course? And they said, no, that is not an individual controlling. It is an automatic controlling. Individually is if there is a lecturer and the lecturer gives feedback individual for the assignment of a student. So if I have the situation that I use in the Moodle course an assignment activity and gave as a teacher the feedback, then the Distance Learning Act is has to be checked. Free courses are not relevant. So if all of these three criteria are in your course, then you are running under the Distance Learning Act. And that means that you have pre-registered your course at the state agency in Cologne here in Germany, and they will approve your course. And they will check if the course is able to give the participants the learning experience as you have announced before in your syllabus. They will check it, they will ask for a service fee for this, and afterwards you can offer your course. It's required 3 to 6 months after they have approved your course. If you are changing anything in your course, you have again, it's required that you go to the agency and ask for a second approval and have to pay gain a fee for this. It's really interesting to see who of the e-learning providers here in Germany knows about this law, and most of them didn't know. But it's in actual law here, an actual act here, and very interesting, this one. A lot of people doesn't matter this one and offer the e-learnings here. Oh, sorry, I lost my screen. So I'm just back here. One part of the Distance Learning Act is how are the contracted closed. The contracted have to be closed in traditional written way, and the participants have an extended cancellation permissions and rights. They can close the contracts 6 months after start of the course. It's not required that they give any reason for this. And so, because most of the courses are not longer than 6 months, most of the courses are very short, from a few hours to a few weeks, they have the right to cancel the contract even if they have finished the course. Curious for me. If it's a course that is running over a long time, for example, 1 year or 2 years, then they have the option to cancel the contract every 3 months. And if they do this, they have the guarantee that they get the money they have paid back. So you have to be very careful with your participants if you are offering distance learning courses here in Germany. So this is a very special German one. But what happens if you are a service provider from outside Germany? I asked also the agency 2 years ago about this, and they told if there is a contract closed with someone in Germany, or if the service provider of the course is coming from Germany, this Distance Learning Act has to be checked. So if you are running from Sweden, if you're running from US, and there's a German participant, based on this law, you need an approval. I'm not quite clear if this is okay with the European law about this, because there are about services in the European area, a lot of regulations. But I think this is a part now for the professional lawyers and maybe also for the courts in the next years, or for change in the act, because it's not reacting on them. So another element is that we have continuous qualifications requirements in a lot of areas of professionals. For example, in health for your lawyers, and in some of the German states also for the teachers. And if you want to offer such a course, you need at first an approval by the organization of the professions. And yes, Andy, it's really so. But what's reality is that most of the service providers are not registering their courses, and this agency, it's a very small agency, don't have the resources to follow up all the offers, because there's no transparency about the offers of e-learning courses. If you want to offer for such professionals courses, and they want to get credits for this, then you have to register your course also by the professional organizations. They have all individual definitions what is accepted as an e-learning course, and how many credits are given to this, and what is a process of approval. And interesting is that in several cases there's a competitive situation because the organization that is approving your course offering also is a provider of e-learning and other courses in this area. So the organization that is in competition with you has to approve your one, and they have to will get in deep information about your course. It's also a curious situation, and but this is reality. I don't know how it's handled in other countries, but this is a way here in Germany in several areas. Not in all professional areas we have such a structure, and health, lawyers, and teachers are the three main areas I know about. Maybe that there are some I don't know about it. So data protection is a big issue here in Germany, and the situation is that we have different sources for this. At first, on the top level, there are some European Union acts. They are in discussion at the moment. We have a Federal Act for data protection. This Federal Act is relevant for the corporates, and we have here in Germany 16 states, and each of them has their own data protection. And the state acts are relevant for the state government, public administration, higher education, and schools. And the acts are very similar, but in detail they are different. And so in some situations you have to check the several acts separately. At the end, we have also for some region or some areas like schools and universities additional regulation. We have a similar situation in the health sector. And what is a special German situation, that the organization have data protection officers. And the data protection officers have a very special role in the organization. I think, Katrin, you know from the university that this can be a long time of a long discussion with them to have a common understanding, what's required, what's possible, what's allowed there. What is the basic of data protection regulation here in Germany? The first one is that you need a reason to collect data, and you have defined it in advance before you are starting to collect any data. And if you are thinking about a learning management system like Moodle, then personal data are stored in the LMS. And they are used in the LMS, and people have access to them. And so it's very relevant to say, okay, what data are stored there? Who has access to this data? And to whom can I give this data as a third party? When should I delete them? What can I do with this data? One element there is I have such use cases defined, then I can collect them. But I have to give all the people with their data I'm storing there, maybe mostly the students, I have to give them in advance an information that I will store their personal data and what I will do with this data. There's a general aspect, so say there's the highest court here in Germany has made a decision that data collection has to be reduced to the minimum. And so not required data are not allowed to store in any system. And you may have an idea that is a very complex discussion with someone who is data protection officer in controlling this. What is required in data? What is required from a legal aspect? What is required from a pedagogical aspect? What is required from an organizational aspect? And these three interests, and maybe others, have to be brought together so that they have all a common understanding and it's clear for all of them. You have to document the processes of collecting data, to interpreting the data, and also you have to define in advance when data are deleted. And this is a very organized process and very interesting and challenging discussions here in this field. So be clear to your participants which data you are collecting, how do you want to use them, who gets access afterwards, with whom do you share them, and when do you delete them. 2 days ago, I read a document in the annual report of the data protection state officer here in Berlin, and he wrote a chapter in this report about data protection in schools, and especially about learning management system. And he wrote there, it's not allowed to store data when students used the LMS, when they used the activities there, and how often they used. This is only a legal point of view on this. And he didn't mention anything about pedagogical aspects, why this data could be relevant, why this data could be helpful for a teacher. And it was only a perspective from data protection and not from the pedagogical processes. And this is one point that is defined in the Data Protection Acts here in Germany, that the reason for collecting has a priority. If you have a good reason and you can define it in advance, you have the permission, you have the rights to collect this data. And so if you have a strong pedagogical process and you say, okay, you need some data to support the students in the learning process, then you can collect it. So here in Germany, all the time, the e-learning teams, I give the suggestion, don't ask the data protection officer what is allowed, because he will say nothing is allowed. Go another way and say, we need data about this and this because we want to use this data for this and this. And this is an aspect, then the whole discussion turns around, and you are in the lead as an e-learning team, but you need also the pedagogical processes to use this. And all the teams that runs in this strategy made a good experience, because then the data protection officer is in the defense situation, and there is, interestingly, no in most of the laws, no special in most of the acts is no special definitions related to e-learning. So all of them is interpretation. So I've spoken a little bit about this data protection officer and what are this for persons, and what is their role there. Each organization in Germany who is collecting data needs a data protection officer. It's someone mostly in the organization, but it's also possible to ask the service provider as external data protection officer. And interesting is that this is a person who is completely independent. There's nobody on the board who can go to the data protection officer and say, you have to interpret the act in this way and in this way, and you have to do this and this. He is independent. Nobody can say what he has to decide, how he has to decide. He can do it. And in the aspect of e-learning, we don't have any decisions from courts. We don't have the situations that details are defined in the acts. So the data protection officer makes his personal interpretation. In March, we had the German Moodle in Lübeck with participants from all areas of learning. And there was a very interesting session from two universities, from University Niederrhein in the western area of North Rhine-Westphalia, and from the University in Wuppertal. It's 100 kilometers between the cities. And both are in the same state, North Rhine-Westphalia. Both have the same Data Protection Act that is relevant. Both have the same regulation from the Ministry of Research. And they have different data protection officers. And they put together the regulations and the interpretations they got from their data protection officer. And we saw in a lot of points that they made controversial decisions. What's allowed in one of the universities is not allowed in the other one. What is a process that has to be covered in one university is quite different in another one. So it's very individual. And this is the consequence of acts that are not related to e-learning. I'm in doubt it will make a lot of sense to have special acts about it. And on the other side, that this data protection officers are independent. So if you have an institution here in Germany and running e-learning, it's a very good idea to have a good connection, to have a good relation to the data protection officer, to discuss open the questions, to discuss your ideas. Yes, Andy, it is. Related to schools, some information, because you can understand the differences in the different states here. In some states, it's required that the parents approve and confirm the use of a learning management system, class by class. And if they don't confirm, if they don't accept the use of the LMS, a teacher can't use it. For example, in Lower Saxony, this is the reality. So before a teacher can start with a class, an e-learning process, he needs a written approval by all of the parents in the class. And if he has 30 students, he needs 30 individual written documents by the parents. With a different situation, Bavaria is the only state that has an attachment in the Data Protection Act, especially for Moodle. Bavaria is just in the process of introducing Moodle for the whole country, for all schools, all teachers. At the end, they will have more than 1.3 million users in the Moodle system there. And they have this attachment, and this attachment defines the general aspects, how to use Moodle, how to store data, what happens at the end of a term with the data, and so on. Hessen is another state. It's between North Rhine-Westphalia and Bavaria. It's in the middle of Germany. And they have the state agency here for data protection needs a contract from a school. And they have to give the approval before the school starts with a learning management system. Lots of schools don't have it, but use also a learning management system. This is also a reality, but this is a situation from this state. And 4 years ago, we started with a state agency and the school organization for Hessen, a legal document for this, how you can have to configure a Moodle system, which data can be stored, and it's was a very cooperative discussion with the state agency here, and it was very interesting to discuss with them, and it was really good experience. And but up to now, this legal document is not set up by the ministry, and we are waiting for this since years. But in other states, the data protection agency have not discussed internally about LMS. They don't have a published meaning about it. And so it's sometimes a little bit unclear situation. But this means in consequence, school can do it, schools can use it, because there's no regulations that have a forbidden situation there. At university is a little bit different because mostly the students are elder than 18. But what's in reality there also is that they have to confirm if they are starting with the Moodle system that their private data, their personal data are stored there, and what the university is doing with them. It's a no-go here in Germany that anyone is using this data and selling this for commercial interest there. So now going into the corporate area. If you are working in a corporate area, there are not so much regulation, but you have to look for your workers' council. The workers' council has to be involved in corporate training activities. They have to be informed about all types of corporate training, and they will discuss typically with the HR department about the offers that the company is doing there. And they have a very special focus, and they say, okay, is there a guarantee that all of the employees have access to the special offers in e-learning? Why? Because not everyone, especially the blue-collar workers, don't have typically ICT workplace. And where can they join an e-learning offer? This is one part. Another part they are looking for is if it is possible to get access not from the working place but also from home. How is the time that the participant is using in an online course registered as working time? They say, okay, learning time typically is also working time, and we have to register this. What will be the process? And some of the HR department have in calculation the situation that they say, okay, people have so much to do at their workplace that they can't learn online in this time, and they have to do it during the weekend in the evening outside of the working time. And the workers' council say, no, this is not accepted by us. Then are there places for learning online? This is very relevant also from the pedagogical aspect. If you have a standard working place, you have customers coming there, you have colleagues coming there, and this is a lot of disruptions in the learning process, and it's not a very good situation. And for the last aspect they are looking for is data protection and privacy, means in detail which of the data from the courses are stored in the files from the employees, and which of the data are put to the HR department. And we suggest here to give only a minimum, and the same minimum as for on-site courses, into the files there. So now one of the complexest things, Urheberrecht. I've written in the headline, Urheberrecht is not copyright. In Germany, very often there is a misunderstanding that they speak with the term copyright and mean Urheberrecht. But it's not the same. We have the situation that if people use the term copyright, then they think about the US situation, but it's not similar. Just ending with a question. Yes, this is one option there. Yeah. And it is good to have such an agreement by the Workers' Council about this, and often there are contracts closed internally in a company. Yes. No, genau, copyright or Urheberrecht. What was a typical special aspect here in Germany? Urheberrecht is connected with the author. And it's not possible to change this situation. It's not possible to transfer copyright to anyone else. But what a originator of a work can do is he can give the exploitation rights to another one, typically to a publisher. This is different in several countries because if I'm going to the US, it's possible to transfer the copyright completely, and afterwards I'm not, as originator, I'm not the owner of the work. Here in Germany, we don't have a regulation of fair use. In US, I can use, for example, for educational purposes, all of the work. It's not a problem, and nobody will put you to a court if you do it. But this is different. If I'm using now in the next minutes the term copyright, it's all the time used in the term meaning of Urheberrecht, and I will go into the details. So, if someone is creating a work, maybe a text, maybe a photo, maybe a drawing, whatever, maybe a film, a video, it's protected. And this is not only for the work that a teacher's creating, but also the works from students. And this is an ownership of the students. And if someone wants to use such a work somebody else has produced, then he needs exploitation acceptance from the originator, from the author. I think the next point is very similar in most of the countries of the world. All the work is protected for 70 years after death of the originator. If someone is translating a work, he creates a new work that is also protected. The typical situation, if I want to give someone else a permission to use my work, is that I make a contract as originator with them, typically with a publisher, and the publisher has then the option to publish the document, and in the contract I have defined the relation about payments. And if I want to use an object, a work that someone else has published, I have to ask the publisher for permission. The original ownership is not transferable. You can, but you can't sell it. But interestingly, this is especially in German. If you are going to the neighbor countries, for example, to Switzerland or to Luxembourg, there is different, because there it is possible to sell the ownership, and it is also possible in US. And to be clear, that is really different here in Germany. So, what can I do with a work someone else has written? I can make a quote from it. But I have to put the quote in a context. It's not allowed to make a collection only of quotation without permission. But what I can do, I can write a long text and put some quotes in it. This is okay, there's no problem. There are some special regulation for educational and research institutions, because there's defined in the Act, in paragraph 52A, that they can use small parts of a work. And there's excluded are the special education books. It's not allowed to take small part of them. And there was a court decision last year because there was a problem in German distance university, and they used a scan from a scientific book in their courses. And at the end, the highest court here in Germany has decided that these small parts are defined as a maximum of 12% of the work, up to 100 pages. So universities and schools can use such small parts there. And they have, but if the publisher is offering a contract for small money, then they have to pay this fee for use of the object and also for the small parts. And this is just an ongoing discussion. And some of the publishers are just creating a company that is offering, especially for the universities, offers that they can sell very easily licenses for their courses, but it's not quite clear how it's going on over the next time. And Katrin, you are at the university. I think there are a lot of discussions internally how you have to document which small parts are used there, and the different states have implemented different processes for this, but I don't know exactly what the reality in the moment is there. But generally the aspect is take care. Okay, you don't have to document. Okay. For schools, a little bit different. There's a contract. Yeah, Andy, it's interesting. A difference between public school and commercial schools. Most of the schools in Germany are public schools. And there is a contract closed, but at first this contract that is closed between the federal ministries and the agency of copyright holders doesn't include the use of the objects in LMS systems. So for us in the area of e-learning, it's not so relevant, this contract. As far as I know, the contract that is closed there only covers the public schools, and not the commercial schools, and not the schools by churches that are non-commercial schools. So they have to make their own contracts. I mean, federal ministries have done it only for the public schools. They are responsible for. Another aspect here of copyright is ownership of own identity. Is maybe mostly relevant if you make a photo and use a photo from someone from your course or another person, then its identity rights have to be accepted, and it can't publish it very easy. You need the acceptance and the okay from the person who is on the picture, if it's not a person of public interest. So, if I am the originator, yes, okay, Katja, thank you. If I am the originator, then my work is protected automatically. I don't have to register it at any area. If I want to give others permission to use my work, then it makes sense that I put such an information directly into my work. And typically there are, also here in Germany, the Creative Commons licenses are used for this. Be careful, there's an option in the Creative Commons licenses with non-commercial aspects. There's a German interpretation of non-commercial, and that means each learning course where the participant has to pay any fee for it. For example, if you are going to the German Volkshochschule and book in for a course, you have to pay some bucks. Or if you are going to a university, you have to pay a fee per semester. And several lawyers interpret that these are related to the license model, commercial offers, because there is a commercial border to get access to the course and to the course content. And if you don't have the fee, you don't get access. And so a lot of teachers and others are publishing their documents under the non-commercial license and don't see that in some of the schools in Volkshochschulen, most of the university will be not allowed in this way to use their document. And they don't understand this. But there's no decision from a higher court about it. And so it's an open situation that is in discussion there. So now coming back to other aspects here, and I think I will come also in the next 10 minutes to the end. We have several Internet Acts, and the owner of a learning management system has to look for this aspect at first: liability for content. The site owner is responsible for all the contents in a platform, but the situation is that he doesn't have to check the content in advance. If he sees there is some inappropriate content and gets information about it, then he has to react. It's not required to do it in advance. And then it will be okay to delete this content or to hide the content so that he can check who has put this content in, discuss with them, and have different steps then. Then it's possible that someone who is the owner of the site gets an Abmahnung, an adhortatory letter. I had to check this term especially because I had no idea how to translate Abmahnung. It's typically a letter you get from a lawyer and say, okay, you have used any inappropriate material, you have used any material copyright protected by anyone else, and you don't have the permission for this. You should not ignore these letters, but you don't have to react immediately. Check the content, delete it, hide it. If you say, okay, it could be possible that it is correct, then really keep calm. Don't underwrite any letters he has offered to you, because otherwise you have directly to pay a fee for this. And go to your lawyer, ask your lawyer, discuss with them how to react. Do it in time, in the next days, but don't go into panic with this. Cease and desist. Okay, yes. I'm learning in this session. So then we have a Media Act. Media Act means mainly for us that an imprint is required. Imprint is also defined. Who is the owner, the organization for the site? We need an information of the physical address. We need a responsible person, and it is written down in the imprint by name, and the contact data by phone and by mail. If available, your tax number or the UID number has to be in the imprint. If you any information missing, it's also a fault and maybe a problem for you. But you need this imprint as organization. It's different if you have a private site, but if you are an organization, if you have commercial interest, if you have a governmental organization, if you're a school, if a university, you need such an imprint, not only for your website, also for your LMS. And put it in the footer or somewhere in a menu that people have information. How can they access the owner of the site? So, and now the last one is about broadcasting. What happens with, why is podcasting and e-learning related? I didn't know about this for a long time. And then I heard about someone who had a webinar, and he asked the state agency for broadcasting for approval for a license for his webinar. And I said, why are you doing this? And he told me that, say, okay, have a look in detail in the Broadcast Acts. And in the Broadcast Acts, there's a definition what is broadcasting. And the point is that they have defined broadcasting is transferring content. We are doing this in our learning courses. Broadcasting is if this is a planned process. Our learning processes are planned. These two criteria, transferring content and this in a way that is planned, is a definition of redactional content. And the third criteria is if you are doing this several times, if you are doing this regularly, then they say this is broadcast if you're doing this online in a situation. And if you have a live situation and we have webinars as a type of e-learning, then really it is broadcast. And what are the regulations there? The regulations there are if you give up to 500 users access to it, you need only a registration. If you have more than 500 users that can possibly access to your course in a webinar, then you need an approval. I think there was a great laughter in the agency for broadcasting Bavaria, where he asked for a license. And they gave him the license for the webinars, because when the Broadcasting Act was written, nobody thought about webinars, and nobody has in mind that webinars could be broadcasting. But lawyers have the interpretation webinars can be broadcasting. But it's a curiosity. You have to take it too serious, but it is a law and it is interpreted in this way. I'm only aware of this one case where someone has done it and asked for the license. So, what happens, what is changing laws is something that is changing all the time. Where are the changes for the next time? At first, federal government is in discussion and preparation of an IT Security Act. And the main points, as I've seen in the draft version of this act, is that the owner of a site has a requirement to update regularly and to keep the site secure. And encryption of sites will be standard. And if you don't have an encrypted site with personal access, you may have a problem with the IT Security Act. It was planned that in June next month, this act should be running through the parliament, but I expect that it will be in the autumn because it's not prepared, and there are some other acts that are now in the running in this same area. Another aspect is copyright acts, and that are continuous changing. And the main aspects our people are waiting in the moment is that on European level, the European Act for copyrights will change in end of this year or next year, and this may have consequences for all the national acts there. One aspect that they are preparing thus in the moment, what is with orphaned works, and it's not known who is a publisher who has the permissions to use them. And if I want to use such a work, it's not easily to find out whom I have to ask. And there will be a regulation in the German Copyright Act that is prepared, and I expect that with the next version of this act, this will be changed, and there will be a chapter about this. These are the acts that are in change in the moment I'm aware about. There's also another one about data protection in corporates and in workplace situations, but I don't see that anyone will be relevant for our e-learning processes there, but we have to wait for the final version of this. So I'm at the end in the moment, and I'm open for your questions, if there are anyone. Okay. Any questions? I think I have told too much. You are bored.
No, not at all, Ralf.
Yeah,
This is
sure.
Vinny again. Just jumping into. Oh, okay. So Andy's going to take the mic. I will use this opportunity while I'm talking just to say thank you again for presenting at this year's iMoot. And I don't want to stop any of the conversations, so I'll switch my mic off and let the questions flow. But just thank you once again, Ralf, for your presentation.
Thanks. Yes, Andy, you can take it. Yes.
Ralf, thanks very much for the presentation. Frankly, if I'd left the microphone on, I'd have been groaning you'd have heard me groaning quite a lot. There are a lot of regulations there, but one comment, and maybe it's a question also, is that I deal with one very large German multinational, and the director of human resources there gave me a tip quite a long time ago, that basing the data outside Germany, actually having your server and your company outside Germany solves a lot of the issues, particularly with the Workers' Council. To be honest, I didn't go to a lawyer about this, but I took the advice, and up to now, it's often been a question from workers' councils. You can't do this. I think there's something called the Technische Überwachungsgesetz or something like that, which restricts the ability of the managers to check what the workers have done on the course. But basing the data outside of Germany was usually a solution that was accepted without any complaint by the Workers' Council. I don't know if you've heard of that or can add to that or tell me that I'm wrong.
Also my personal opinion, and I can say only my personal opinion about it in a moment, that is really quite different. At first, most of the countries, most of the companies have internal regulations and definitions where their data can be stored. And we have to do with a lot of such organizations, and most of them say our internal definitions that the data have to be in the protected area in the European Union, maybe in similar states or countries, or especially the data have to be stored in Germany. And these are also multinational German companies that they say all servers only have to run in Germany. That's the first one. And if the HR department says, okay, we want to store the data outside of Germany, Europe, then ICT department will be involved and say, no, it's a no-go.
No, I didn't.
The second one, the location where the data are stored is not relevant for the internal processes, from my opinion. Because the data are collected, the data are used, and it's not depending where they are stored. The relevant is that they are collected and that they are used, and the purposes and the people who get access to them is not related to the location of storing the data.
Okay. In this case, the service provider, the training company, stores their learning data and their logs outside.
Okay. This is an external company that is storing the data.
Absolutely, yes.
Okay, that is another situation. If I don't have a corporate LMS, if I have a service provider that's offering the training and they are storing the data anywhere else, then this is another situation. But then there will be a contract which information of the participant success or fails will be given back to the company.
Yes, exactly.
Yes. Then I am completely with you. But on the other side, it will be very often this case that also in the LMS courses are high risky information from the company, from the internals of the company about products, about processes, and they are not allowed to give this information into the processes of a training provider.
Yes, definitely.
Yes. Okay.
Thanks very much.
Any more questions? Lothar, something from your side? Okay, so then let's close the session. We have a recording of this. I will finish the recording now. And thanks for coming.